Now a look at the Obama administration's policy on Guantanamo Bay detainees. Assistant Attorney General Tony West talked to the American Bar Association about the legal issues involved. This is a half hour.
As I now turn to announce our speaker, I want to give special thanks to Mary Smith, who is part of our committee and I think was instrumental in being able to have Tony West come to our particular breakfast. Tony is the Assistant Attorney General for the Justice Department Civil Division. He was confirmed on April 20th, 2009. This is the largest litigating division in the Department of Justice. The Civil Division represents the United States in legal challenges to congressional statutes, administrative policies, and federal agency actions. These includes defending the recently passed health care reform legislation against constitutional challenges, litigating national security cases such as the habeas corpus petitions brought by detainees at Guantanamo Bay, which I think Tony will be addressing today, and providing support and guidance to agencies responding to the recent oil spill in the Gulf of Mexico. The Civil Division also defends the President, cabinet officers, and other federal employees in lawsuits filed against them throughout the country. Tony has had a distinguished career of public service. In 1993 through 94, he served as Special Assistant to the Deputy Attorney General Phil Heyman, during which time he worked on the development of the National Crime Policy, including the 1994 Omnibus Crime Bill. From 94 to 99, he served as Assistant U.S. Attorney in the Northern District of California, where he prosecuted child sexual exploitation cases, fraud, narcotics, interstate theft, and high-tech crime. From 1999 to 2001, he served as Special Assistant Attorney General of California, advising the California Attorney General on matters including identity theft, high-tech crime, the Microsoft antitrust litigation, civil rights, and police officer training. Prior to returning to the Justice Department, Mr. West was a litigation partner at Morrison & Foerster in San Francisco. In private practice, he had a number of high-profile cases. He was part of the defense counsel for John Walker Lynn, and I think he demonstrated his commitment to due process and the legal process. I think that has marked his entire career, is always doing the right thing. He's been a commentator on ESPN, CNN, and CBS. He was born in San Francisco, graduate with honors from Harvard College, where he served as a publisher of the well-known Harvard Political Review, and received a law degree from Stanford, where he was elected president of the Stanford Law Review. We could not have a better person in the United States to come and speak to us about the Civil Division and the habeas litigation, and it's my great pleasure. I hope you join me in thanking Tony West to come to the podium. Thank you.
I think I want to bring Harvey anywhere I go with that introduction. Thank you very, very much. Let me express my thanks to Harvey Rishikoff for inviting me here this morning, and thanks also to Holly McMahon, who I think I met on the way in. Everyone tells me that she gets it done and makes it happen. So thank you for bringing us together this morning. It's really a pleasure to be here this morning to speak with you about the work we're doing in the Civil Division to promote and protect the nation's national security. The work of this standing committee, of course, is so important in furthering the scholarship in this area. You really encourage a dialogue on these issues, and your influence certainly is far and wide. As Harvey mentioned, Mary Smith is a member of my senior team at the Civil Division, and I couldn't do my job without her good work. So I appreciate all that you do, and I appreciate very much the opportunity to be here. So let me start with full disclosure. I think I have one of the best jobs in Washington, D.C. I absolutely love my job. And the reason is, as many of you know, the Civil Division represents the United States in courts all over the nation in a wide variety of matters. Essentially, we are the federal government's law firm. We represent the President, the Cabinet, federal agencies, and Congress, and we have over 1,000 lawyers, over 400 support staff. We're the largest litigating division in the Department of Justice. Nearly every aspect of federal government operations and nearly every aspect of this administration's domestic, national security, and foreign policy priorities, they at some point come through our doors. And so it's an amazing opportunity to see that variety, to be a lawyer in this day and age, and to be at the Civil Division. And probably nothing we do in the Civil Division is as vital to the safety and security of the American people as our work on national security matters. Indeed, there is scarcely a week that goes by where there isn't some significant, often controversial national security issue that crosses my desk. And the largest amount of my time in this area has been spent on wartime detentions of individuals held at Guantanamo Bay. Now, currently, there are about 140 active cases involving Gitmo detainees who are challenging the legal basis of their detention. 3 years ago, as you all well know, the Supreme Court held in Boumediene that Gitmo petitioners have a right to habeas and that they can challenge the legality of their detentions in federal court. Can you all hear me okay? Is that all right? Oh, good. Now, since then, the Civil Division has defended these cases on behalf of the United States in court. And that effort has required a tremendous amount of resources. It's required dozens of DOJ attorneys, hundreds of thousands of hours of DOJ time. And this enormous effort stems from the fact that, as you know, these are uniquely challenging cases where the stakes are so high because both national security and liberty interests are at issue. And there is a tremendous pressure in each of these cases to get it right. I've spent many a late night in the Justice Command Center with Civil Division attorneys, grappling with very difficult, often novel legal issues of an evidentiary nature, things which courts will confront for the first time as we talk and think and try to decide how to proceed in these cases. And when you add to that a history of skepticism that has hovered over the legality of detentions at Guantanamo Bay, you have quite a challenge. As President Obama has said, following the tragic events of 9/11, our government, motivated by a sincere desire to protect the American people, made a series of decisions that took us off course and undermined the integrity of our efforts to defend the detention of individuals captured on the battlefield. Now, detaining battlefield captures to stop them from re-engaging in warfare, that in and of itself is not particularly controversial. Indeed, that concept really is as old as war itself. The challenge, however, is to litigate these Gitmo habeas cases within a framework that offers an accepted legal basis for detention that's bounded by the rule of law, as well as procedural safeguards that are both robust and fair. So how have we done that? How have the Obama administration and this Department of Justice, how have we litigated these important habeas cases in a manner that is grounded in the Constitution and consistent with our nation's unique values? I think over the last 2 years, we've done so in two significant ways. First, this administration stated for the first time that the legal standard underlying the President's authority to detain individuals at Gitmo, that must be rooted in congressional legislative action that draws guidance from the common laws of war. And second, through our district court and appellate court litigation, we've developed important procedural safeguards that ensure that detainees have a meaningful opportunity to present their habeas cases to neutral federal judges, because the legitimacy of wartime detention is advanced and our national security is enhanced when the government proves its case in a process that's perceived as fair. So I'd like to talk about those two developments because I think that together they have really allowed us to meet our #1 priority of keeping the American people safe, consistent with the rule of law. So a legal standard that's rooted in congressional authority and informed by the laws of war on one hand, coupled with procedural safeguards that are just and reasonable on the other. Let's take a brief look at each. First, the substantive legal basis for detention. On this point, I think there is some common ground. We are a nation at war, and the courts have, in the many Guantanamo cases that they have heard, have repeatedly agreed with the government that the President has the authority, consistent with U.S. law and long-standing law of war principles, to detain those who are part of the enemy, part of enemy forces in an ongoing conflict. This is what the Supreme Court essentially held in Hamdi. But while the fact of the government's wartime detention authority, while that may be fairly settled, the breadth of that authority, that is, to whom it applies and under what circumstances, that has been the subject, as you well know, of much debate. And to inform that debate, this administration in March of 2009 established a definition outlining just who may be subject to the President's detention authority. That definition indicated that the President, that the government may detain those individuals responsible for authorizing or participating in the 9/11 attacks, as well as anyone who harbors them. It also indicated that the President may detain persons who were part of or substantially supported Taliban or al-Qaeda forces or associated forces engaged in hostilities against the United States or its coalition partners. So this definition, which we have come to call the March 13th definition, it has formed the substantive legal regime underlying all of our habeas cases. And importantly, it is backed by two sources of legal authority. First, it is based on a duly enacted congressional statute, the Authorization for the Use of Military Force, or AUMF, which authorizes the use of force against organizations and persons connected to the 9/11 attacks, as well as those who assisted or harbored them. And second, the March 13th definition draws upon the international laws of war to inform our interpretation of the statutory detention authority which has been conferred by Congress through the AUMF. So, for example, while the language of the congressional AUMF, while that speaks directly to al-Qaeda and Taliban forces, longstanding law of war principles support our interpreting that authority to include other armed groups who we have confronted in Afghanistan and who are fighting with al-Qaeda and the Taliban. And when civil division lawyers, when we brief these cases in federal court, we take great care to articulate how the scope of our authority under Congress's AUMF is supported by these legitimate and established principles. Notably, we have not relied on claims of independent constitutional authority under Article 2 as a substantive basis for the President's detention authority. Now, we've presented the March 13th definition in case after case in the federal courts, and repeatedly it has been upheld. And by testing our authority in the federal courts, we've underscored the paramount importance of the rule of law, and we've lent, I believe, substantial legitimacy to the government's actions when it comes to detaining enemy forces. Now, of course, applying a relatively straightforward set of principles as articulated in the March 13th definition, that can prove a little challenging in practice, especially when you apply that to an organization like al-Qaeda, which operates in violation of the laws of war, which doesn't have any formal enlistment procedures or uniforms. It has a very diffuse command structure. It operates in many cases clandestinely throughout the world. Take, for example, just the principle that those who are part of enemy forces may be detained. That part of definition. Courts right now are grappling with just what it means to be part of al-Qaeda or part of the Taliban. Every single case that presents this issue, I think, poses a unique challenge involving individuals who have differing degrees and types of associations and connections with these terrorist organizations. And the D.C. Circuit has, in the course of applying the March 13th definition and developing the law on this point, they have given us some guideposts identifying some highly relevant facts to the inquiry. For example, to be considered part of, a person has to have a sufficient link to the organization. It can't be a freelancer. Evidence that the person received or executed orders or was otherwise integrated into the formal command structure of al-Qaeda is both relevant and sufficient, but not necessary in every case. Travel patterns consistent with al-Qaeda are highly relevant, as are associations with al-Qaeda members, because that might show trust and acceptance by the group. And attendance at al-Qaeda training camps and safe houses that were used to facilitate training and fighting by recruits, that can be strong evidence indeed. Now, in addition to this legal substantive standard that I've been discussing, the courts have worked very hard with the help of the Civil Division and the detainee bar to develop procedural safeguards that are fair but which acknowledge the unique nature of these habeas cases. So two important takeaways here. First, fairness. Courts must have procedural tools that enable them to conduct meaningful reviews of the lawfulness of the government's action when it comes to detentions. And additionally, detainees must have a fulsome process that allows them to test the legality of their detentions. Both of these are necessary for a process that has legitimacy and integrity, particularly when the government's detention determinations are upheld. And we in the Civil Division, our lawyers, we have embraced certain procedures to help ensure meaningful review and fair process. For example, we've worked hard to create a process that allows habeas counsel to review classified evidence. We've taken on significant discovery obligations to provide access to classified material in government files that could prove helpful to a detainee in challenging the government's case. Detainees have the right to present their own evidence, including the right to testify in court by remote video from Gitmo. And the burden of proof rests with the government, not the detainee. And we must demonstrate that the detention is lawful by a preponderance of the evidence. Now, the second takeaway is this. These cases are unique, and they require procedures that take that uniqueness into account. More often than not, the evidence in these cases comes from a faraway battlefield, obtained under circumstances which is nothing like you'd see on CSI, for instance. Often the evidence is years old, based on hearsay in many cases, and much of the time it comes from interrogations that were conducted for intelligence purposes in circumstances which are very different than the Mirandized police interviews all of us are familiar with. Given these unique circumstances, courts have taken a pragmatic and a balanced approach to the evidence in these cases, such as viewing the evidence as a whole, as opposed to evaluating each evidentiary piece in a vacuum, as if prior established facts did not exist, or accepting that hearsay is admissible, but recognizing that it's only valuable if a judge has a way to test the reliability of that hearsay. And while the evidence we rely on in these cases is often unconventional, we've been unequivocal about one type of evidence we will not rely on. Information that the government concludes was the product of torture will not be used to defend these cases. On this point, the President and the Attorney General have been crystal clear. Torture is abhorrent to the rule of law and to our fundamental values, and our lawyers who litigate these cases, they take these allegations of mistreatment very, very seriously. They've been quite diligent and painstaking in investigating such claims. And frequently this has involved our lawyers tracking down, years later, actual interrogators involved in an alleged incident. And to the extent that there are plausible allegations of detainee abuse, we carefully examine the surrounding circumstances to reassure ourselves that any statements we seek to use from that particular detainee are sufficiently attenuated from any alleged mistreatment. So to sum up, we defend these cases because we believe that Gitmo detentions have a solid legal basis to justify them. That basis is grounded in congressional statute and informed by the laws of war. Further, we believe that the procedural safeguards we've developed ensure fairness for detainees and a framework for meaningful review by the courts. And the evidence we present, while unconventional, is reliable and untainted by torture. Now, of course, courts don't always agree with our assessment of the facts and the evidence. And when we lose, courts have issued orders directing us to release detainees and take diplomatic steps to ensure their resettlement. And when they've done that, we have complied with those orders, or we have appealed if we believe there is a sufficient basis. So I believe that in litigating these difficult cases, we have struck the right balance. We've been able to do so in a manner that keeps the American people safe, is consistent with our Constitution, and reflects our best values. And I think I want to close by just saying, in a week when federal government employees have been taking it on the chin, we've been able to accomplish this goal primarily through the excellent work of our career civil division lawyers, our career paralegals, our career staff who are responsible for litigating these habeas cases. These folks really, in my mind, exemplify something that I learned over 15 years ago when I was a young Department of Justice lawyer in Maine Justice. Back then, I had the good fortune of doing much of my work for then Attorney General Janet Reno. And just before I left Maine Justice to return to my home state of California to become a federal prosecutor, she asked to meet with me one-on-one. And during that meeting, she showed me an inscription which is carved on the wall just outside of her office, which reads, and I'm paraphrasing, "The government wins its case when justice is done." And she told me then that my job as a prosecutor was not to go out and win as many cases as I could, although don't get me wrong, I did win all my cases, but to do justice in every single case that I handled. And I have to tell you, that is the same spirit that I have seen exemplified in these career civil division attorneys and staff. That team that handles these cases day in and day out, I could not be more proud of the work that they do. And while in doing our best, we may not always get it right, I can assure you that we always try to do what's right. And I think that is the critical difference. So I'm thankful for that opportunity, and I'm certainly thankful to speak with you this morning. Thank you.
Tony has time to take a few questions because he's on a tight schedule. So I think we can take 2 or 3 questions. Ruth, you have a question.
Well, thank you for those very eloquent and gracious remarks. A couple of questions from another old trial lawyer. You've talked about the standard of proof, which is preponderance. You didn't talk about sufficiency, how much proof you have to get that 51% probability. So if you could address that. Secondly, what about fruit of the poisonous tree? Mm-hmm. The Obama administration has said torture is abhorrent. We all agree. but the old rule is any fruit of it with a very, very thin degree of causality required should be prohibited. What do you think about that? And finally, why only Gitmo? Why not Bagram? Why not the rest of the world?
Such easy questions. And I'm mindful of the fact that C-SPAN is filming everything I say. So I'm afraid that means it may be a less than satisfying answer. But on the first question, on the first issue of the sufficiency of the evidence, I think that these not only the standard preponderance, but exactly what it takes to meet that burden is something which we have fleshed out more and more with each case. So we know some things get you there. We know that some things don't. I think the most significant thing I can say about that is the standard that district courts, according to the D.C. Circuit, should apply when looking at the evidence is really a functional analysis, a functional test. That is, do you have evidence of the person going to close safe houses that are typically associated with the Taliban and Al-Qaeda? Is a person traveling certain routes that are typically traveled by fighters? Is the person going toward the battle as opposed to away from the battle? Is the person associated with known Al-Qaeda or Taliban members? And then taking all of that evidence as a whole, the totality of that evidence, as opposed to evaluating each piece individually, I think that informs a court's ability to determine whether or not we've met that burden and we made sort of the 51%. As to the second question, you'll have to remind me.
Oh, taint.
Taint. Well, look, I mean, I think that's where the attenuation analysis, I think, is quite helpful, because I think for us, we will not, and we've been very clear, we will simply not use evidence that's the product of torture or mistreatment. And if we do seek to use statements, we have to reassure ourselves that any taint has been removed because there's been, say, a change of circumstance, a change of interrogators, a movement of an individual from one location to another, so that they no longer fear that they may be subject to alleged abuse. All of these things which we draw upon from traditional attenuation analysis, they become very relevant here. And I think that helps create a safeguard against using evidence that might be tainted. And then the last one is, why not Bagram? We just argued this case, I guess, about a year ago, so I think I'll rest on our papers, and we were successful there.
Sir.
Following 9/11, the definition of a terrorist organization, global terrorist unit, was modified to expand the definition to include organizations or entities that gave material or financial support to terrorist organizations. The U.S. government has used that as the tool to go after Islamic charities here in the United States that it deemed were providing financial support to terrorist organizations. But I'm curious because in October of 2010, the Senate Armed Services Committee declassified an investigation which they named, I think, 4 U.S. security contractors as having made payments to the Taliban and to local warlords in Afghanistan who are known to be participating in terrorist activities. And there's been nothing. There's been silence from the administration. As far as I know, there's been no effort to seize their assets, to move against them in the same way that the previous administration has moved against Islamic charities. Could you comment on that and tell us whether there are any plans to bring these people into the same?
You want me to reveal ongoing investigations?
No.
No. I'm kidding.
If you could just comment on the fact that the U.S. government has used these laws to go after Islamic charities, but there has been nothing with respect to U.S. security contractors who've made payments to known terrorist organizations.
Let me, I won't comment on that specifically because in all seriousness, obviously, if I were to comment on it, it could reveal ongoing investigations, and I don't want to get into that. But I will say that that issue is one in which it gets thorough vetting within the administration as to you know, when a government action is taken against any entity or any individual who falls within the ambit of that statute. That is something that is thoroughly vetted, not just at the Department of Justice, but obviously with the involvement of the Department of Defense and the Department of State and the intelligence agencies to the extent that that's appropriate. And I can tell you that there is no differing yardstick that is applied to one type of organization or individual as opposed to another.
Well, I think one last question.
Thank you very much for your comments. In them, you quite correctly relied to a great degree on the congressional authorization and saw that as the ground for a lot of the authority that you have to be acting in this area. And yet, both the definitional steps you've taken and the procedural steps that you've developed in court have been done exclusively through executive action without the contribution of the legislature. Will the administration be proposing legislation to codify some of the definitions and processes that you've developed, and if not, why not?
Well, I think I'll answer that this way. We have seen, you know, there was, I think, a degree of uncertainty about exactly what the proper standards were, what the proper procedures were in the very beginning, soon after Boumediene. But I do think there has been, over time, a development, as I've described, where courts have now have a working set of standards, a working framework, which has developed through, I'd say, the common law that's emerged here. And it's been quite instructive for district courts. You know, I think it's fair to say that, you know, Congress obviously is interested in these issues. We have an ongoing dialogue with Congress, which I think is very constructive, and we will continue to have that. But I do think that what's developed has been quite helpful.
Great, thank you. It's exactly 9 o'clock.
All right, you need to leave. Thank you.
And I want to give you, thank you. I don't want to give you more work to read to keep you late at night, but this is the coveted U.S. Intelligence Community Law Source book that our committee puts out.
Thank you.
We're working on a 2011 edition, so I'll make sure you get that one too.
All right,
but this
Harvey,
will help you. Thanks
so
a lot.
much.
Thanks for coming.
I appreciate it. Thank you so much.
Thanks. Good.